Good evening, everyone. This is a joint meeting between the Planning Board and the Open Space Preservation Commission. At this time, the Planning Board does not have a quorum, so I'm going to turn it over to Mrs. Luttrell, and then we'll move on with the first agenda item. Mimi.
The Open Space Preservation Commission does have a quorum, and we are now in session.
Very good. This is first agenda item is the Mass Audubon presentation on the open space. Jeff, good evening.
Good evening. Thanks very much. I'm Jeff Collins from Mass Audubon, Director of Ecological Management. You could tell me how you'd like to array ourselves here.
We're going to sit. Yeah.
Great. Should I turn and
No,
face?
you're going to be on this one.
Okay, not that camera up there? Okay, great.
Yep.
Okay.
I know, he's talking about that.
All right. So as I said, I'm Jeff Collins, Director of Ecological Management at Mass Audubon, statewide land conservation organization. I also direct our Ecological Extension Service, which is a technical assistance program through which we help conservation partners such as towns and land trusts address their land conservation and land management issues. Over the years, we've done a lot of our own land protection. We own 30,000 acres across the state, and we've looked at land use change across the state through our Losing Ground series, and we offer towns assistance with their own open space planning through our Shaping the Future of Your Community program. So because of that experience, we responded to this request for proposals from the town to review the status of open space created by the Southborough subdivision bylaw over the past several decades, and to offer comments on the level of protection for those areas protected by the bylaw. We worked closely with town planner Jennifer Burney, members of the Open Space Commission and the Planning Department, Freddie, Mimi, Jesse, and Andrew. In terms of our skills in this area, I've worked a lot with other towns and land trusts on reviewing their conservation restrictions, which typically involves looking at a restriction document, a recorded legal document, looking at the underlying deeds for properties that are protected by conservation restriction, looking at plans, historical intent of a donor or the person who protected the land. And that involves a lot of research in the Registry of Deeds that led right into this project. Initially on the team was my colleague Valerie Massard, she was a full-time employee at Mass Audubon. She had previously been a town planner in Plymouth and brought a lot of the same skills. Before the project and to put together the team for our proposal, worked with Elizabeth Roblica, a land use lawyer based in Western Massachusetts, who will be speaking later. She brought great expertise to the review of open space protection status. And then also Hannah Lyons-Galante joined the team to really lead the collection and review of legal documents, building a database, and building the maps that were one of the products for the report. I just wanted to say that open space law is, from my perspective, complicated and esoteric, and that land trusts, all groups that protect land, have will eventually come across some issue where despite their best intents and best review, there's a little bit more that could be done to button up permanent protection of a piece of property. And when we talk about permanent protection, it's really hard for us to get our head around, but we're talking long past the time when we're gone. We want that land to be providing the open space values that we've identified in the intent, or meet the intent of the protection action. So the town is really to be commended for going through this exercise of reviewing their open space. We'll get into our summaries, our findings. A lot of the land that was intended to be protected through the subdivision bylaw is in good shape. A lot of the land, a majority of the land, is protected, but there are some sort of belts that could be added to the suspenders, so to speak. And there are a few areas where we had questions where we thought that the planning board and the town could take a closer look at the status of some protected land. We'll go through all of that. We'll deliver to the town a GIS shapefile, which is a computer file that we used in mapping software to precisely identify where the open space is based on the plans that were drawn up and submitted. A database full of information on the various parcels that are protected, the documents and the historical process that led to that protection, and all of those documents, hyperlinked so that they can be searched and used going into the future. In terms of the process, we came to agreement on a list of subdivisions to be reviewed with a working group made up of Open Space Commission members and Planning Board members. We assembled all the plans, deeds, and decisions associated with those and various other documents. We created summary histories of the protection activity. Elizabeth reviewed the history and the intent and the documentation to offer comments on the level of protection and any improvements that could be made for those various subdivisions. We geo-referenced the plans, which, as I say, is bringing that into a mapping software package so that we can then draw the lines of where that open space is, and that can be used by the town engineer to track that open space, and we assembled that all into a database. We looked at 42 subdivisions, 235 parcels, over 500 deeds, dozens of easement documents, and plans and decisions for all of those subdivisions. To show you some of those products and walk through a couple examples, I'll introduce Hannah Lyons-Galante to come up and speak. She'll use the screen and the projected information.
Yeah, if you want to, I guess, face this and look at that and show the TV, you can pick Hannah up so she doesn't have her back to the audience. Will that work?
So facing this way.
No, you can face the audience.
I can face the audience. That's
Yeah.
gonna be all right.
Yeah.
Okay.
Okay,
Just
'cause
gotta
that will
grab a
be,
microphone.
that'll be too
Yeah.
strange.
Hello, is this on? All right, so as Jeff was explaining, we used mapping software, GIS, to find all these parcels, to map out all the parcels of land that either are open space, an open space parcel, or contain an open space easement in Southborough. And the way we did this, this is, as you can see, zoom out here, the basically keystone shape, right? That's the town boundary. And if I have an aerial photograph on this map, I take a plan, I can essentially peg it onto that aerial photograph and then draw the open space. So here's an example of one. I have this plan on here, and I've pegged it to the property boundaries that I can see from the air, so usually stone walls, those are really helpful, and then I've drawn out those easements, in this case, or easements, on the back of these lots. That's Andrews Way. So this is one of our products that we will hand to the town engineer as in order to further steward this open space. And it's as accurate as as our research is, so I'm going to say very accurate. And you can compare this as well with other GIS information, so town engineer can really use this as part of their work. So just one instrument, an extra tool in their toolbox, if you will. Now, our second deliverable here is a database. So as much fun it is to take data and visualize it in really interesting ways, we think that's pretty useless if you don't know what the program is. So we created an Excel table. Many people are familiar with Microsoft Excel. It's easy to use. These are drop-down headings that allow you to search if you want by subdivision name. So say I just want to know only information on Admiral's Glen. I can drop down, and then here I have only information on this one. It's actually a condominium development. So it's one giant parcel. All of the information in this table, particularly location identifier, that corresponds to assessor's information. So you could say if the GIS were the spatial part, the database is really going to be help the assessor get up to speed on open space or which parcels have open space, because it's all linked. We've used assessor's information in this table to link our information, in this case on open space, to this actual real piece of data in our that's already being kept track of through the tax assessors of Southborough. So in this table is the subdivision name, the developer's name, the open space area that was approved, how much is actually showing up on GIS, thankfully very similar in most cases. Decision, there's a link to documents if the decision was recorded. You have the book and page. So we are not only tabulating information, gathering it in this table, but also linking it to actual documents that I'll show you in a moment are stored on Google Drive. So I'm not going to go into all of this. Now, this data table is really cool, but it doesn't capture the entire story that we're trying to tell of how this open space was created. I could look at data all day long, but it's not going to tell me what actually happened. So our tool to tell the story comes from a subdivision summary, essentially a Word document that we put together. I'll show you where it's stored in a moment, but the links to it are in the table for each subdivision. We put together a subdivision summary for every single subdivision, so 42 summaries, and these are legal I could say it's a chronological order of documents pertaining to how the subdivision was created. When was a special permit issued? What was the site plan approval that went through? The plan, subsequent plans, and includes the deeds to the subdivision, or the deeds to the subdivision, deeds to the actual parcels within the subdivision, and the language, most importantly, the language that's in that deed that relates to open space. So in this case, a master deed doesn't have explicit open space language in it, but it references these specific plans, so that show open space. And this chronology and storytelling, essentially, allowed us to pass, to give these summaries on to Elizabeth Rubica, who are our partner in this and our land use lawyer, to read through all these documents and give her interpretation of how well this land is protected, the open space is protected. So there are 42 of these summaries. They're on their own, it's a lot of jargon, it's a lot of, you wouldn't maybe not necessarily want to just go read all of these, but if you were looking at this table and wanted to know more information, looking in the summaries where you're going to find it. So, and it really captures the language, the legal side. So those are our three deliverables. As you can see within the summary, I'll explain about Google Drive in a moment. You can see within the summary there are hyperlinks, and these hyperlinks, if you click on any of them, it will come up with a special permit. So in this case, a special permit, but in other cases, a deed, a decision, an easement. And these are publicly available documents from the Registry of Deeds website. However, you can't link directly between the Registry of Deeds website and these, and directly to the website in order to find this document. So I have stored all of the documents for every single subdivision in a folder structure on Google Drive. So if I have Google Drive, this on my Google Drive account right now, but I can very easily pass this information off to the town in one giant folder, or the town can download it and we can deliver it on a CD. But all of these folders, like here's Admiral's Glen, it's all the information about the summary is in the summary, the deeds, the plans, they're all in this folder. So that's where these hyperlinks are coming from. I'm not hyperlinking to the registry website, but to a Google Drive folder structure. And yeah, that's it on the actual physical, what the town will be getting. We now wanted to go through a few of these subdivisions in order to better highlight the places where some land was well protected, places where could need some improvement perhaps, and places, areas that's there's a problem that the town can look at further to resolve. So Elizabeth is going to help me with this. I'll introduce give you a background on the subdivision, and she will comment further on the legal side on how well protected it is or not well protected. So just start off. Which one do you want to start with?
You just go in order.
Just go in order? Okay.
And we chose this sampling in particular because it provided a wide range of techniques. So it will allow us to highlight what was used most often and what, in terms of how the planning board issued decisions and what developers did with the conditions in the planning board's decisions, and then how the developers carried out the open space protection. There's a wide range of techniques.
All right. So Blendon Woods, this is a pretty bad view of the plan. The plan's kind of cut off. Is a subdivision created early on in the bylaw process, and they, on 3 of the lots, well, it's now 3 lots. It used to be 4. The lot lines changed, but it's the same amount of open space. On 3 of the lots is a easement running across the back of the lot, and the easement is comprised of a covenant and a conservation restriction. So this is just one example of how the bylaws manifested in this one subdivision, and Elizabeth can comment further on what those.
Oh, you have to. So, you have to scroll down to my conclusions. I don't have them.
Oh, you know, okay, all right.
I don't have them. I didn't know I was supposed to print them out.
Oh, no,
So you have to
it's
go
fine.
back and
Here we
open them
go.
up. Okay. Yeah. So, for example, if you were going to look at, we can just start at the beginning.
Oh, sorry.
If you were going to, I can do it. So that, because then, so I reviewed all 42, and this would be how you might approach when Hannah said this is the piece that tells the story. So in this Blendon Woods subdivision, they always start with the subdivision plan, so, and usually the definitive, and she gives you the recording information for the plan. And then she will add any sort of conditions, or if there were a special permit or anything, and sometimes there's a subsequent plan. And so it starts with the planning board information, and then it moves on to the covenant. So if you wanted to start with the plan and see what the planning board, or the decision to see what the planning board was requiring, you could sort of start to figure out what the developer was trying to do. But we're going to skip all that each time. I'm just spending a lot of time on it, so you sort of see how it flows. So then I would look at the actual documents. I would look at the plan, I would look at the decision, and I would look at the actual documents to see how it was carried out, and sort of just give my opinion as to whether or not that parcel that was intended to be open space based on the planning board's decision was actually protected as open space. And as I said, there is a wide range of techniques, and we're trying to give you a sample of the various techniques used. So here we have a restrictive covenant. Can I click on it? Will that come live? But I want to just go down for 1 second. And these are all the lots that had to deal with open space from the subdivision map that Hannah just showed you. So with regard to the restrictive covenant, which covered the 35-foot strip, it's valid restriction under Mass General Law, Chapter 184, Section 27. That's the statute that pertains to restrictions, as it refers to a benefited and a burdened parcel. And so I get kind of specific here. I'm just going to click on the restriction for a second, just so you have an idea what I'm talking about. So we would go through these documents, Hannah and I, we'd read them and sort of decide. I would decide legally. She would find them, and then I would sort of give my legal opinion, though I want to make clear this is not legal advice, but in my opinion, this was a fairly well-drafted document. So now I need to go back. If you just kind of redo that. There we go, thanks. So I wrote a summary of what I thought about the restrictive covenant. I recommend that a notice of restriction be re-recorded. So the thing about restrictions is that they expire in 30 years, and they need to be re-recorded. And that is if in their body of the original document, it has a time limit. Usually it will say 50 years or 99 years, you'll see restrictions. So after 30 years, it needs to be re-recorded, and then every 20 years, it needs to be re-recorded. If the actual document itself did not have it was unlimited as to time, or it had no reference as to how long it was good for, it expires after 30 years. So this is an interesting point. You think, so the planning board's requiring a developer to put a restriction on. The developer does that, but because of the way 184-27 works, it expires depending on how it was worded, and then whether or not someone re-records it. So later on in the recommendations, we'll talk about whether or not this is a good technique or a way we could maybe be more permanent in terms of trying to carry out what the planning board intended by having the developer put that restriction in place. The second document that we looked at was a conservation restriction on the 15-foot strip, which was in perpetuity, pursuant to Mass General Laws 30. Can I click on it? Okay. And I found this lacking because it did not meet the terms. No, this is a restrictive covenant. How'd that happen? Okay. Did I just not click on it right, or just, it was a 336. Maybe it's.
So if there are any issues with this, I'm happy to fix it this week. send it right back.
But that's okay. So, but the point is, my summary was that it's not a valid conservation restriction because it didn't meet the requirements of the statute. So my recommendation was that an amended and restated conservation restriction could be recorded. However, at this point, it would be each lot owner granting the conservation restrictions. That would be difficult to do. Usually, the beauty of starting with the developer is it's one owner and he's granting out as he goes, and then so each subsequent deed is encumbered by the original restriction. So you want to sort of nail it at that time. But so at some few of these we're looking backwards, saying what can we do now? Or in this place, can we go back and fix it? So in this case, that would be difficult to do. But I guess so. The point with this one, and we're going to go through about eight or nine of these, the point with this one is that conservation restrictions are very specific in how they need to be written and signed, and to put them in place effectively. And in this case, that it wasn't done that way, but we'd be happy to help you understand how that works. Okay, so you want to go on to the next one?
That was just one example.
Oh, and then we wanted to say you could ask questions throughout if at any point this doesn't make sense.
Definitely.
And should we start with the subdivision plan or the planning board decision so you can sort of see how this unfolded? This was, I forget the date of the subdivision.
This is 1988.
88, so you could maybe get a sense of, maybe we should start with the decision just to show them, the one that had conditions in it.
Correct. So number 8's next. All right, so this one's a little more recent. I think it's better, easier to read this decision. 1998.
Did you want to talk about 1s, 2s, and 3s, or color coding or anything?
We should do that sometime.
Yeah.
All right, should we do that right now? Interrupt.
Sure.
All right, we'll get into number 8 in a moment. Just wanted to introduce this idea that you might have seen on the map. It's like, why is that yellow? If I zoom out, you can see there's some yellow, there's some green, and actually very few red. So as you might imagine, the colors correspond to what we deem our opinion on how well protected that parcel is, or that easement, how that well protected that open space is. So 1 is red, there's a problem, so some sort of issue, and it's not to say that that open space is in any way built on, or there's not to say that it's not being respected. It's just there's an issue in the way that it was doled out by the developer, as we'll see in a moment, or missing a signature on a conservation restriction. So often very minor, and very, very few problems. The majority of subdivisions we looked at are in this yellow category, which needs improvement. it's there. The open space definitely was intended to be protected. We have some recommendations the way it could be better protected. And then green is you're good to go. You know, they're well protected in our opinion. You know, often owned by Southborough Open Land Foundation. You know, we're definitely our conservation land and will likely remain so for a very long time, as long as, you know, Southborough Open Land Foundation stays in.
So,
business.
for example, that last one we coded as a yellow because it was protected, but it expires in 30 years because of the way the restriction was written, and the conservation restriction would have been great if it had been done as a valid conservation. That would have been a green, so it was a yellow.
Yeah,
So
so
in
here's
the end, you'll be able to
this.
sort of look at the whole town and figure out where to focus, where the problems are.
Yeah, so if it's missing signatures or there's, again, very few of these red ones, but the yellow is the restrictive covenant. It's going to expire. All right, so now to number 8. Here's the decision. Did you want to go through the decision?
I wanted to give one that had conditions, but
Yeah, this one usually.
this
So
isn't one.
all decisions, as you probably know, say this subdivision was approved on this date, this plan was approved. Now the dates are very important on that plan. I've made if you know, you have to pay attention to which plan this is pertaining to, because often there are multiple decisions related to a subdivision. And then the conditions are also really important because if they pertain to open space, that's what we were looking for. In this case, I don't see any open space conditions. There's another document here, and on the very condition number 4, here's approving another plan. Open space easement will be added to provide an extra buffer to adjacent residential developments.
Let's stop here. So this is an interesting example, just because one of our recommendations is going to be how decisions might be written to be more clear. Because remember I said there's all these technicalities with when a developer does a restriction, but however, when the planning board has a decision and that decision gets recorded, which often happens with planning board decisions, that's good forever. That doesn't need to be re-recorded. So if the planning board decision had a little more information in it, for example, a dimension of a buffer, how wide, maybe more specifics about shall remain in its natural condition, whatever you're thinking. Maybe you didn't intend that to be, or the planning board this time didn't intend that, but if you did have more specific information in your conditions, and I know the way it usually plays out is, you know, then the developer takes and then there's all kinds of, you know, between now and 2 years when it's finally done, there's the building inspector. Lots of people are looking over everybody's shoulder. But on record, which is what's enforceable, could be the decision with more specifics in it. So 30 years from now, when someone's trying to figure out if this parcel is protected, consistent with what the planning board intended, it would be nice if the condition within the decision was more specific.
So when you go into the actual, this is the summary, it's the same.
So the decision, the planning board approved the definitive approval makes no reference to open space. The decision was not recorded. The plan is recorded, and often on the plan, if you want to call up the plan, it will have an open space label, right? I don't know if this is one.
So if I open this plan, this is really hard to see. I'm actually going to go back.
Let me zoom in.
So I'm going to go into the annotated plan version, which is color coded. So there, in this package, and this will all be explained to the town planner, there are definitive plans, and then there are these annotated plans that I colored so you can see the open space much more easily. It's been looked at on paper, you color it in, scan it back into the computer. So that's where the open space is. That's what they were referring to as these buffers.
Right. Okay, and then so how did the developer carry out the planning board's directive? You just scroll down.
Homeowners.
So Danforth Development reserved to itself an open space easement. When it did that, it created an easement in gross that does not run with the land. So maybe we could just look at the restriction itself. I can explain what I mean by that.
The declaration of covenants? No, is the bylaws? Or actually a deed. All right,
The,
deed from, so there's a deed to lot 1. Oops, why did I
no,
say that? Try deed to lot 2. So,
here we go. Reserving to the grantor. That's the landscaping, together perpetual non-exclusive reserved to grantor. Oh, here it is, reserved to the grantor's successor sons, perpetual non-exclusive open space easement. The grantor being the developer. So this isn't about a benefited burden parcel as the first one we saw. It's not a restriction that runs with the land. It's not something the holder of one parcel is going to hand off as that parcel gets conveyed. They reserved to themselves, so the grantor, meaning Danforth Development, could come in and enforce it if a grantee of this deed did something to violate the open space easement. But I'm not sure if they're even still around or if they would have the intent to do that. So this isn't a great technique for the developer to grant out, reserving to itself an open space easement, as opposed to, for example, creating a homeowners association, or perhaps a homeowners association holds that easement, creating a common scheme where each lot owner can enforce against other lot owners. We have examples of that. Perhaps granting the parcel itself to the Conservation Commission or to Southborough Open Land Foundation, all of those techniques that you're familiar with. This is an example of not a very good technique. So.
yeah, just wanted to, there were not many examples at all of this, I think.
Right, there's usually an actual, it usually deals with a specific parcel as opposed to an easement gross, which means personal to the developer. The developer holds it. So, yes.
What was the name of this one?
Bradford Oaks,
Danforth
Metacomet Lane.
Development. Well, you'll have the information.
No need to take
Marked
notes.
it as a 1 because we thought that was a big issue, that if the development corporation is granting the easement to itself and the corporation then dissolves, well, where does that protection go? There's no entity who's holding the open space.
Back on the spreadsheet, you don't have to go there.
Mhm.
Just, sorry, just saying.
On the spreadsheet, and we don't need to go there, but because many of these subdivisions over the years went through multiple names, are they all listed?
Yes.
Because I think often when they started out, many of us would not recognize the name that it ended up.
So I, in all of the hours I spent looking at these documents, could not figure out the order in which they were named. I mean, that was just way too much detail, but I listed all of the names. So if you know by 1, it will be in the, the subdivision name column. It might be in the alternative name 2. I think some subdivisions have 3 or 4 different names.
Thank you.
Fortunately, not many. All right, you want to talk about number 19 and 23?
Hidden Meadows, sure.
This is interesting. So here we go.
So what happened here? Okay, the planning board granted a certificate of approval of a preliminary plan. We've not received a copy of the final approval. However, the definitive plan includes a planning board signature, subsequent A&R.
So
you just
should
keep-
I just show?
If it had open space on it,
I can show the 2 plans.
sure.
So this is an instant that happened a lot. This is just something we found what happened a lot. So you have a definitive plan. You create someone goes out and surveys the property. This is off Middle Road, Hidden Meadow Lane. They created this plan. They created surveyed the property, and you can see the buffer of open space, the open space easement around outside of the development. So it's an easement going across the lot.
And it's labeled. What is it labeled?
yeah.
Open space easement.
25-foot open space easement. You can see, well, it's hard to see. But now, there is a subsequent, what happens now is there is a subsequent plan. So an A&R plan was filed. So the definitive plan is from 1989, and an A&R plan was filed, so a new plan was made in 1994. And what happens, oh wait, is this, sorry, I'm clicking on too many links. Is there an annotated? I have an annotated plan that shows this a lot better. So here's the definitive plan. And then the A&R plan in 1994 takes one of those strips of open space around the outside of the development and moves it. It moves it back. So all of a sudden,
Want me to scroll it?
sure, well, I can just touch it. All of a sudden, this existing easement is going to be abandoned, and the entire 25-foot strip of open space is moved to the outside of the development. Now, you could say this is the original approved open space, and now this is being moved out to the outer rim. Now, you could say that this is, well, you're taking open space, just moving it, it's the same amount, there's no loss of open space. But we found this to be an issue, and
Well,
Elizabeth will explain further.
and this also highlights a very common technique, which is the recording of the plan with the label of open space easement on it, which similar to when I said if the planning board decision is recorded and the planning board decision contains language, there shall be a 25-foot open space buffer around the perimeter. And then you also have a plan that mirrors that condition. This is on record. This does not need to be recorded, obviously. Any deed out, a deed for, say, lot 18 would reference the recorded plan. They don't even need to say in the deed contains, subject to a 20-foot wide open space easement. All they have to do is reference the plan because the plan shows the easement. And in that regard, it's pretty well protected because the plan's on record, it never goes away. And any deed out will reference the plan, because that's what we do when we deed out lots from a subdivision. We reference the plan for the description, for the legal description for the property. And anything on that plan is, the lot is subject to that. But the point Hannah's making is that so it's pretty well protected, but then again, maybe not so much, depending on if you care that it got moved, that a subsequent planning board moved it in a subsequent A&R plan. I don't exactly know how that happened. I'm not sure if it was intentional or what, but so.
This seemed to be a case in multiple instances where the A&R plan is totally, all the documents we looked at, and just so you know, all the documents we looked at are from the Registry of Deeds. So these are recorded documents. They're not like some person just brought this over to the planning board, signed it, and then it went away, or it's in their back room of their house. No, these are publicly available documents. So someone went through the process of creating this plan, bringing it to the planning board, and having it signed off as what they call an approval not required plan. So as you know
what that is.
They're not creating a new road, you're not doing anything dramatic, you just need to have this approved. You don't need to go through the entire approval process.
Did you say this happened often? I didn't think that happened that often.
Well, there were, let's see, so we have 3, well, what happens is not so much specifically open space movement, but there are subsequent plans filed, A&R plans filed for these subdivisions. So to add to the potential.
That isn't carrying through from the original directive from the planning board.
It might not carry through the original directive. Your deed might say references this plan, and that plan often shows the open space, but it's possible that it won't, or there can be confusion created by these filings. And if the planning board signs it, you say, well, you would assume that the planning board approved it, and that's okay, right, to move the open space. But it doesn't. It calls into question more the permanence of a planning board deeming this strip of land open space when a future planning board could change the location of that open space. So I would say it's something to look at. So we can probably skip ahead then.
Sure. We have about 20 more minutes.
All right, perfect.
You want to go to Mount Vickery?
Sure.
Which one did you want to skip to?
I could even skip to 35, but I can go to Mount Vickery is fine too. I can show you this again on what happened at Mount Vickery Estates, where here you have a very standard looking, oh, I wish I could zoom out. The yellow is the open space easement. It's around the outside, the perimeter of the subdivision. Now, if you look at lot 5, keep looking at lot 5. Here is a more recent plan. So there's lot 5 in the bottom left corner, and they've decided to put in a tennis court. So they went through the process of, and they bought the parcel that's just north of, or actually south of their property, so to put in this tennis court. So they bought this giant parcel behind them, behind their lot, and they've moved the open space easement. It's hard to see, but they've moved it so that it's now entirely to one side, to the left of that tennis court. There's a new proposed, I think it says proposed open space easement that's basically replacing, or it's swapping land. So you're taking the same square footage of the existing open space easement and putting it into that new open space easement that's being created, and you're eliminating that back lot, right? They wanted to extend their yard and put in a batting cage. So here's an example, again, another A&R plan. The planning board signed it. It's documented. It's a recorded plan. And you've moved, the open space has been moved. So something to think about. All right, so now you want to do 35?
Sure.
Okay. So
Presidential estates.
this is a fun one. And is it okay to just be showing these plans? I know it's kind of washed out on the screen. Is that all right? Okay. So maybe people can see these. All right. So is this okay to show, or should I go to the GIS? Maybe GIS is better.
That's good.
Yeah.
Except we got to flip to the summary.
Oh, it's true. All right, let's go to the summary first. First, the legal summary. Let me zoom in.
All right, so 1986, we have an approved plan with the following modifications: that 31 be set aside to fulfill the open space requirement, and the approval is subject to the agreement of I'll do it. Parcels F and E never be subdivided. Okay, so
there's a lot of language on this summary. There were a lot of modifications, and this was a particularly large subdivision. So we went back to the very beginning when it was first proposed, and then went through all the documents that are, they first put in building restrictions and covenants, and then they do a restated building restrictions and covenants. So reading through all these documents to look for any language related to open space, anything that would then have jurisdiction or be a legal document that might call out open space, that would then be have say over the lots. So we're not even, these are just descriptions of these documents, and then as you
this is good wording. So I just want to point out paragraph 12 here that she excerpted from the building restriction conditions, that those portions of the lots designated as open space or open space area on the plan shall be left in their natural state. No structures or improvements shall be constructed thereon with the approval of Northside and the planning board. I think that meant to be without the approval of the planning board, right? So, okay. So then there were all the deeds out, and we sort of wanted to keep track of what happened to lot 31, right? And did we other parcels too?
So,
oh yeah, E
well,
and G.
these would be a good example of a well-protected area. So not parcel D, but F. All right, or no, it is D. excuse me, sorry. So parcel D open space is a lot, was deeded to Jasinski, excuse me. So a private owner. And then Jasinski deeded this lot to the Southborough Open Land Foundation. And in that deed, there are conditions, or they say the premises are conveyed subject to restriction of no hunting of wildlife, cutting of trees, etc. Essentially outlining this lot as open space to SOLF, right? So great, awesome, it's protected, it has this deed, SOLF has the deed. That's an example of a parcel that was well protected.
Before you go on, I think there is one example of where the deed is silent. The deed is to, I believe it's SOLF or the town or Concom, I don't remember which entity, but it's silent as to, for conservation purposes, it's just deeded, which means, in my opinion, that it could be used for other purposes.
Yeah.
However, if you sort of look at the open space plan, the definitive subdivision plan, which has that parcel labeled as open space, and the deed out to a conservation entity, even though it's silent, you could sort of make the argument. But my point is that when you're deeding the parcel in fee, it's called the fee interest, the whole parcel deeded to an entity, it should at least reference for conservation what the purpose is for open space protection, which this one does.
Yeah, so there are some parcels that are owned by the town of Southborough that we gave a 2. We said, it's not quite protected enough because it doesn't explicitly say that that parcel is for open space. Now,
for example, the select board could decide it needed it for some other purpose. If you had given it to the Conservation Commission in the care and custody of the Conservation Commission, or for management for conservation purposes, that's often how you will see a deed to a Concom with Article 97 protection or pursuant to Chapter 48C, which is the Conservation Commission's purposes and their ability to hold land. Those sorts of references which make it clear the town could not later vote to convert to some other use, such as, and this is a debate, you know, active recreation versus passive, so a ball field or a school or that sort of thing. So if the intent is to protect as open space, that recitation should be clearly in the deed, even though you think it's protected because you're giving it to the town.
do you want to talk about the lots and then get to lot 31? Like how
You
the
mean
lots-
EG? We should just go down. So preservation.
E and G, this is an interesting one. E and G were not labeled as open space on the plan, and they're subsequently deeded to the Preservation Trust, which
Great.
Elizabeth looked up the Preservation Trust, and their mission is protecting land. So
Yeah, it wasn't like a hidden name, you know, like, oh, they're really a developer. They just call themselves the Preservation
yes,
Trust.
so they're a land trust, and they're legally they filed with the state government. They're a legal land trust, so well protected land. You could say that. Now,
So parcel F was labeled open space. That's what you mean by the quotes on the plan,
Yeah.
right? And this is what happened. This is the history of parcel F.
that's a mess.
You want to go through it?
Okay.
You know it better than.
Parcel F is a different story.
Quickly go through
It's
it.
essentially a large parcel that was labeled on the plan as open space. Now, you would assume that that parcel would then be deeded to the town or to a conservation entity because it's huge, and, you know, owning a forest is kind of a lot of work or a lot of money to pay property taxes on that. So the Northside Corporation held that parcel for many years. What happened was the lots adjacent to it were developed. There was a subsequent A&R approval process where lots below that parcel were developed. And eventually, parcel F was deeded to Beth A. DePietri, excuse me. I'm terrible at pronouncing things. So she now owns, she's her lot, her house, presumably, abuts parcel F, and now she owns parcel F. Now, her certain plans don't necessarily say that parcel F is open space. They'll just say it was now or formerly Northside Corporation, the land of Northside Corporation. So if you were to say, well, parcel F is protected because it's on the plan that says it's supposed to be open space, well, not all plans show that. Now, so
This one did.
this
though,
one
right?
happened to, and when Elizabeth looked at all this, she said, well, look, it says open space on this original plan, and if so, Beth
Just
really,
because it got dropped from the deed doesn't mean you get to call it something else, because you go back to the plan. Because, so the reference, the description for that lot, F, is the plan that's recorded, that's called, that says open space, which is,
Yeah.
I think I did say in the planning board decision, it would be helpful if it had more detail on the plan itself, because if you're not going to record your decisions on the plan itself, often you will have conditions or notes or more specific labeling for parcels, anything more as specific as you can. And I know it's often the developer who's presenting these plans to you, but if you can require that the conditions be reproduced on the plan, open space, forever its natural condition, 25 feet wide, or however wide you want to say it, anything that you put on that plan, which is good forever, would help with the argument later on if you're trying to make that this parcel is to be protected. For example, if it gets dropped from the deed, which happens.
and yeah, so this is the case for the open space areas, or I would call them easements. They're portions of private land, of lots that were deeded out to private landowners that are the back portion of a lot that were deeded out, and they will often say in the original deed, this is supposed to be meant to be open space, the 50 feet easement. Not all the deeds, subsequent deeds repeat that language. Again, as long as those deeds reference a plan that show that easement,
Right.
you're good. So that's what happened with all of the rest of the lots in this subdivision. And then we can talk about 31.
Okay.
So
You can just see just the reference to the plan over and over again. And this is the deed she's giving you. The premises are subject to the restrictions as shown on said plan. Okay, so lot 31.
So lot 31 was deeded to Douglas Backman, and it references the original definitive plan, and it shows, this original plan shows half of lot 31 as being an open space easement, having an open space easement. So should I show that? I can
Sure.
show that. So the original, actually, let me do that. Where's the original plan? I have to go all the way back.
You know these so well.
There's a lot. Okay, this is a mess. Actually, can I use
The annotated one.
the
You want?
annotated one better?
Here, I'll scroll. You can go stand up there.
Well,
You want to point? There
here
it is.
So here's the,
See the open space area? There it is. Yeah.
so you can see there's lot 31, Glenwood Road, and then
Right.
it's not half of lot 31. You could say a third of the lot. It says open space area, 184,000 something square feet. So it's a fair amount of open space. Now, that's in 1986, I believe, or actually, excuse me, not 1986, 1989. Anyway, this is the definitive plan. It was recorded as
So
this
then
is,
what happened? Get
Yeah.
to where we're going. Sorry, we only have 5 minutes left. We are.
So what this lot was deeded out with that plan in mind, or as the reference. And then in 1998, you have an approval not required plan created by Mr. Douglas Backman, which shows, hard to see here, you can see lot 31, the original lot, is now divided in two, land of Douglas Backman and lot 31D and lot 33C. So he's created two new lots, essentially subdividing his own property. And the planning board has signed off on this plan. The new lots don't require any open space. They don't have any open space on them. But if you remember, his land still is still subject to that original plan of the subdivision. So in this case, because he's not drawing out the lot lines for his lot, it's new lots, he doesn't have to show, or I'm assuming, he doesn't have to show easements on his own property, right? It just says land of this person, right? So that's what happened in 1998. And then I looked at the newer deeds. They don't mention any open space. So Lot 31 technically is still subject, or his land is subject to the original deed and original plan of the development. Now, this particular case, and I know some of you already know this, what happened here, is for whatever reason, went through a legal process. This is all legal. There's now a house on his land, on half of where the open space originally was supposed to be. So I'll show you what that looks like. Here is Presidential Estates. I'm going to zoom in. You can see the sort of the yellow. And here is Lot 31. Everyone see it? Where the original easement's supposed to be. And if I take away the plan, you can now see that he's built on the easement. So this was probably the most ridiculous case of perhaps miscommunication, whatever, of open space. We didn't find, this is the only one, like built structure, permanent structure we found on open space. Maybe Elizabeth can speak more to what might have happened, but
shows it.
this is essentially, we don't have any more. I looked and looked and looked for more documentation on the planning, on the Registry of Deeds. Couldn't find any more documentation of what might have happened. So all I can presume is some procedural, if the building inspector is supposed to check up on this, or if it's this signature or that signature, or any kind of misunderstanding, that's a stewardship issue and not on the legal side of things. There wasn't really any law breaking, you could say. Mm-hmm.
I had a question.
Yeah.
I had a quick question. So I don't know if you're able to answer this off the top of your head, but if you had to quantify it in percentages, red, yellow, and green, could you at least throw out?
Most were yellow.
I would say 90%, 85% are yellow. And then you have, pardon?
80, 10, and 10, something like that.
Yeah.
I'd say 80% yellow, or could be improved status of protection.
Or even 80, 13, and 7.
Yeah.
13 being green and 7 being
13%
red.
in good shape, 7% just a handful of.
That's a red, right?
Well, the thing is,
We should wrap up to let you get to
Wrap this
your
up.
next agenda item.
This is
but
it's definitely a steward. You might want
but
to
it just
comment on
to-
this one, yeah.
just to comment, a difference that I think Hannah was trying to pinpoint there between the protection status and then the stewardship. In terms of looking at the intent in the legal documentation of this piece of property, the mechanism for protecting it was, could have some improvement, but it was legally protected. Now, there are some other small, examples we could go through in detail with Jennifer or the subcommittee at some point, where there might be an above-ground pool that might inch into the easement, or there may be some storage or something that's in the back strip intended to be protected land. And so I think a next step of the Open Space Committee might be, the stewardship sweep of how that land is being managed, is being recognized as protected space. This, I think, was the only egregious example we saw. Again, assuming we found every document and there was no similar kind of swap to those examples that we set out earlier, but we didn't find anything like that.
That's a really important point. I mean, this could be a green from a recordation standpoint.
That's right.
But be something else altogether from the stewardship standpoint.
Right.
Yeah, so from a legal perspective, we're like, well, it's all right. The parcel, the easement reference is on the plan.
It's because if you go back to the A&R plan, so presumably the surveyor who prepared the A&R plan would have had the definitive subdivision plan, would have seen the definitive subdivision, which had the big chunk of open space shown, right? So the A&R plan should have carried that forward, unless there was some sort of an amendment, which maybe there was, maybe we didn't find it. So the A&R plan should have had the open space, so it got dropped, and then the building permit got issued based on the A&R plan, so you sort of just kind of kept going. And then, you know,
Yeah.
the line got lost where that open space line was intended to be, so.
As part of your deliverable, I mean, I know for each subdivision you wrote your legal conclusions, but I was just curious if there's some, you know, broad sort of assessment about this stuff, maybe in the, I don't know, like almost an essay, sort of summarizing and going through just the overview.
Yeah, so the final product will include a sort of a methods section of how we went through all this. As Hannah said, the database, the GIS shapefile, the summaries, and all the documents. And then we have a set of recommendations that we can leave some copies behind here, and we'll compile those and sort of offer additional comments.
But this one, like, for example, this isn't so much a legal recommendation as more sort of housekeeping, how you carry forward. I mean, legally, the plan's on record. If someone wanted to enforce that, it's there. But it's like, I'm almost thinking when a A&R comes before you, there needs to be some list of, you know, some checks so you can look at definitive subdivision plans before you sign off on the A&R. You know, or you require that. It was one of your requirements of materials is it definitive. Show me the definitive first, then show me the A&R, tell me how they line up, show me where the building's gonna go if you know, maybe they don't at that point, but that sort of thing. That's not illegal so much. So I didn't actually write that recommendation though. I'm just thinking, do you require as an A&R the material be the definitive? Is that one of the, I don't know. So that would be a sort of a quick fix. To adjust what you require to have before you sign off on an A&R. Do you want to go over the recommendations or hand them out, or just don't have time?
How's your time? Okay.
Oh, okay.
Do you have the stack?
It's right here.
So from a, we are not, we can't say that it was within a scope of our services here, our consulting services, to go through every single lot and say that this person put their fence up in the wrong place. Like that was not part of this project. We were really just trying to get a sense of where the open space was, how was it created, what were the documents that are backing it up, have a legal opinion or some legal review of this, not a formal legal review, but enough to give you a sense of how well protected these parcels are. I put in this database under the column irregularities is if on this particular parcel there is any kind of encroachment, or if there's someone's pool or a shed or a lawn. I wrote appears to be partially landscaped. Now this is what I'm looking at on the GIS, so I didn't go there. I don't know what it actually looks like, and it could be very well fine. It could be there's no encroachment. It depends. You need a survey to go out there and find out where the lot lines are, and GIS is not 100% accurate, but it can give you a sense if you wanted to know, how well protected this open space is, but what's the quality out there? How is it actually being adhered to? That's in there.
Okay, so just quickly, the first recommendation is that the decision, as we've already talked, your decision could include a condition that open space easement or the open space area, whatever you're talking about with this particular subdivision, be created with a specific size reference to the area and specific restrictions on the use of land, such as, at the very least, the land to be set aside as open space shall remain in its natural condition, if that is the intent. So what you saw is a label open space easement or open space area, and I think by default, if there is no more than that, either in the planning board's decision or on the plan itself, one would go to the zoning bylaw to look for what the definition in this town, what Southborough considers the definition of open space. So you could use that as a guide. If you're happy with that and you didn't mean to say more, then you don't have to. But if you want it to be slightly more restrictive than your zoning bylaw to protect it a little bit more, then you could add words to that effect. Many towns record the planning board decision. You file them with your town clerk, that's not on record. You could require that they be recorded. The final approved plan should not only depict the open space easement, but should also contain the notation reciting the planning board's condition. Number 4, the most effective way to preserve open space is to deed the land to the Conservation Commission with Article 97 protection, or deed the land to an active land trust for the purposes of open space protection. The second most effective way is to put a conservation restriction on the property. Number 6, open space restrictions that are imposed by a developer as part of a common scheme need to be re-recorded in accordance with the statute, it's 184, section 27, to remain effective. It's fairly complicated how that re-recording works. That's why I didn't recite it here. I just recited the statute. But you will see a developer imposing restrictions on the lots that are conveyed out. That's called a common scheme. They could have anything to do with the size, the height, the color of the community, or open space restrictions in particular areas. They need to be re-recorded. In order for a common scheme restriction to be enforceable, the subdivision needs at least 4 lots. And the lot owners could also enforce against each other. That's important. And the building inspector is your zoning enforcement officer. Your building inspector is the one who would enforce a violation of an open space easement or area on a subdivision plan. So the procedure would be call the building inspector. They enforce the open space, or lot owners can enforce against each other. And then in order for it to be extended, as I mentioned, it needs to have a time period in the original document. It can't be silent or it expires in 30 years. So this is why I say it's probably easier to just put it in your decision or on the plan, because once they're recorded, you don't have to worry, and be clear about the dimensions and what you're trying to protect.
And a lot of the plans I looked at, the more modern the open space, like more recently the open space was created, the better the plan was explicit about exact acreage. And I think that also comes with easy, the software that people are using to create those plans. You say, all right, what's the acreage of this polygon? Okay, what's the acreage of this? And it shows up. It's great.
Yeah. Okay, any questions? Yes.
First of all, I want to say excellent job. Really, really great. Lots of work done here. Just a few questions and guidance. One of the words you're using is natural condition. Well, in this town, I think there's been various opinions on what that means. So do you have recommendations for future definitions that we should be adopting? The other thing is there's different types of open space. So you have the easements that wrap around. You have the larger parcels of open space. And in your opinion, is that the same? And meeting with SOLF in the past, they're not always interested, or land groups are not always interested in easements that wrap around. So recommendations on how we could protect it if a group like that isn't interested, or a Concom isn't, what would be the best way? Do you have recommendations, and maybe this is next steps for future of us working with Mass Autobahn, but stewardship, boundary markers, etc., tags and trees.
Yeah.
And then, I think that's all I have for now.
So in terms of capturing what's permitted and prohibited within the easement area, or restricted area, that can run to pages, and yet can be very effective. So I think Mass Land Trust Coalition or the State Department of Conservation Services may have a model conservation restriction, or Southborough Open Land Foundation, Sudbury Valley Trustees and Mass Audubon would all have examples of.
If you're looking for a few paragraphs, you're looking for a few 1, 2, 3, 4, what it might say as a.
Well, I am, but are they different? So that's the thing is
there are, and that's
the easement. So you wouldn't have the same language for an easement, or would you?
No,
versus
because for example, a trail corridor.
Right.
is just open because it's not habitat. But natural condition means generally that you're not mowing or you're not affecting the habitat. Or you could just say undeveloped. Undeveloped means no man-made encroachments. So there's degrees.
Right.
It's a little bit depends on what the goal is with the subdivision, what's already existing on the ground, what you're trying to protect. So it's probably not one size fits all. In fact, a lot of these easements doubled as corridors. They were for right-of-way, and that's recreation is a recognized form, recognized conservation value.
Exactly.
So that could be, the easements are very effective for.
And I think that's the difficulty that we have is we try to put it on one size fits all.
Yeah.
So that's where we need the help is what is allowed, what are the different types, and making that clear in the decision, because then we get into problems later on where, oh, the intent might have been for something else and the planning board might have understood it that way, but then, you know, it's used in a different way. So I think that's really where we need help is establishing those different types and what is allowed.
Yeah. Now the issue with open space, meaning many different things to different people, gets to that and to the question of the shape of the open space. If you're going to have 1 acre, is a 1 acre strip around the back of the lots equivalent to a 1 acre sort of square lot? And again, that depends on what the planning board and the community is valuing open space for, generally and at that location. Coming from primarily a wildlife habitat protection perspective, I'd say that the narrow strips around the back of the lots are not performing much of a role in terms of wildlife habitat, especially if they're narrow, 30-foot strips between subdivisions. But as we saw in one of the decisions there, the strip was intended to provide screening between houses. So if the intention of the community is we don't want to be so dense that we're looking across the back fence at our neighbors, this is the style of development we want, then that's a valuable service that open space provides. To the extent that habitat protection is a goal, the more core area you can provide, the better. Meaning, there's say a 50-foot strip between development and forest or habitat that wildlife will sort of tend to avoid or certain animals will avoid. The more of that core area, forested area within, away from that buffer outer strip will be valuable. So a square or bulk round parcel would be more valuable than a narrow strip. Having the open spaces connected, so where you have one subdivision has gone in 2015 and you created that 2 acre parcel, then in 2025, if the adjacent parcel is being developed, see if you can direct that open space to be adjacent to the former open space. So now you're building up large core and connected areas.
Yeah, but in terms of getting you some wording for various degrees that you could insert depending on what the situation is, I think we could do that. Like, for example, the screening one, I was even thinking if that just said open space, to me, I could argue that maybe you could put up a shed or, like a swing set, something that's not anchored or doesn't require, you could get around. And if you really wanted to be vegetated screening, that would be
Right, and I think
different.
And I think open space and planning agrees that if there are various types, if it's going to be a wildlife corridor, then what is the minimum? 3 feet obviously isn't going to meet that requirement. So I think we need help, and I don't know if that's part of this or a future project, but further establishing what types are allowed, how you would protect those, what would be the wording, and what's ideal.
Now that the open space is found, you could say, we've have this great GIS file, or it's a shape file that's you can share between GIS, the mapping program. So anyone could, we'll give it to you, the town, anyone can use it who knows GIS to then map out use other pieces of information on open space in this area, in this region, and that could be easily be mapped to look at areas that, for future, if they were to be developed in the future, that you could then use a map of open space as a resource for figuring out where that, where might be a good place on that development to be corner off as open space.
So I think to wrap up, well, we will answer any more questions, but we will talk about getting you connected with the staff in our Shaping the Future of Your Community program, because this is one area where they engage with communities to answer precisely those questions, and they can, you can start that conversation and then figure out what the list of needs are next, and then what they can provide.
So I just wanted to point out that when we're looking at the open space, and as the planning board correctly states, not one size doesn't fit all. But partially that is because this open space has been set aside under 2 different sections of our zoning code and the planning board's rules and regulations, so that when you have the flexible subdivision plan, which has a larger amount of open space, those requirements are defined differently than what is allowed in just the regular subdivisions. So there's some of it, but I think what I'm hearing is that actually calling out on the plan and in the decision what the open space intent, the planning board's intent or the requirements, is a really good place to go, in addition to having the deed protected, which our bylaw requires, at least for the flexible subdivision.
Recording that decision, so putting that decision into the registry of deeds, the book and page, and which can be then easily found, because I don't know if maybe you didn't notice, most of the decisions were not recorded in this project, and they were given to us by you, the town. So they're now in this hyperlinked Google Drive, but I can't, as a member of the public or a neighbor, can't go and look up that decision without coming to the town.
Can that be done after the fact? I mean, could we now record old decisions?
But it wouldn't be in the title of the deeds that have already been deeded out. But the plan is what gets referenced in the deed. So it's the notation on the plan, which usually recites the conditions from the planning board decision. So it's both. It's the planning board decision, then it's the plan with the notation on the plan, because that's what people will look at.
And just to the recommendation, so not all of the open space requirements are going to be the same, but is there general language you can supply for specific anticipated cases? Like when you want it to be for wildlife habitat versus a trail versus, like a lot of those easements, they're not corridors like for trails because there's no public access allowed. So, if you wanted to make sure it was for public trails, you'd need a different sort of language. I don't know if that's something simply that a couple of lines that might be recommended to be in a decision
Yeah, we can work on that.
as part of this project.
Let's, well, what I'll do is I'll talk with the folks in the shaping program and see, what their work plan is and what level they can engage. And we'll figure out how to make our work most useful to moving forward in that regard.
And again, I just wanted to thank you for the level of detail and the work, because we worked really hard on designing this plan between the Planning Board and the Open Space Commission, coming up with the outline, but it was pretty overwhelming to know exactly, what we were going to end up with, and I think we've gotten above and beyond what our expectations were. So thank you very much.
You're welcome.
Question?
Yeah.
Sam Stivers, 7 Presidential Drive, interested in the presidential estates thing. I'll pay a visit to some of my neighbors tonight. And a member of the advisory committee, but I'm speaking as a private citizen. First, great work, something that is long overdue, should have been done 30 years ago. Second, can I get a copy of the documents that you presented tonight in the database? I'm very interested in looking at this.
I'm not sure that it's
That's up to the town. So we
final yet, is it?
As a consultant, we're gonna we'll package this up and give it to Jennifer, the town planner, and then everyone, all of
But-
you can decide how.
It's a public document,
It is
so
a public
certainly,
document,
Yeah.
Yeah.
certainly you'll get it, but I just was saying, referencing the fact that it might not be a package yet.
Okay, all right. I
We
guess
have to
I'm
figure out the best
interested
format.
in getting report data access to this stuff. Be very interesting to look at. And next, I apologize if I've missed some of this in here, but it certainly seems to me that it would be wonderful to take advantage of the organization and structure that you've provided to this as far as linking documents in here, to link it back into the GIS system or provide some sort of a database that the public could access to say, I want to know about this particular subdivision or whatever, and this is obviously far from comprehensive for the town. On the other hand, it'd be a real shame if we somehow lost the ability to have people able to go in and read the documents as you organized them here in ways that are easily accessible, which, again, it's all electronic here. It's not rocket science at this point to put it out there in ways that the public can actually follow the trail if they're interested in these particular areas. I expect that there are actually some residents of some of these subdivisions who would be very interested in being able to track through this on their own. So is the plan to actually do that, Freddie?
Actually, the plan is exactly to do that. One of the things we were really aware of when we were asking for the deliverable is that the program they gave us was something that anyone would be able to use. So it wasn't a special, you'd have to have own a program that the public didn't have or a license. So I believe most of it's all on Excel. Excel, so, you know, we can use it.
Yeah.
And then also the GIS is another part of it that it's just supposed to go on the town's website.
Yeah, I mean, it seems to me linking this information into the GIS at some point to say, okay, here's a subdivision, what do we know about the subdivision? Well, you know, here's the string of deeds and easements and whatever that are related to the subdivision, would be a great public resource. And ultimately, we frankly ought to be doing that for all parcels in the town. I mean, this is, you know, we're about in the 18th century in terms of data access and information, unfortunately, and this, I think, is a great step forward. So, thank you.
You're welcome. Thanks.
Well, again, thanks for the working group's involvement, for Jennifer's help throughout the project, other town staff, for Elizabeth's time and expertise reviewing the summaries, but especially for Hannah's time, really loads of time for the whole summer, spring, and fall, pulling together all the documents, the research, building the database, the GIS, relating it all, building the summaries, making the hyperlinks, and creating the product that you saw tonight. So we'll package this all up and hand it off. And we always sort of, you know, we don't put it in the mail and disappear. I mean, we're a long-running organization at Mass Audubon. We develop long-running relationships. And I've been happy to have a long relationship here in Southborough dating back to an open space and recreation plan and work at Breakneck Hill, et cetera. So we'll make sure that it's made most usable way, or delivered in its most usable format, and followed up to be of most use going forward. Thanks very much.
Thank you.
I just had a couple questions. When's the final deliverable due?
Jennifer, there was a question about is there a due date on the final deliverable?
We don't need that right now, but it would seem to me that currently the information that you have here is a draft. It's close to a final draft. And then once we get the final deliverable and it's reviewed by the town planner and interested people from open space and the planning board, and then you get the green light that says, thank you, you're all done with this project, and you can submit for final payment. Then that document, I think, would become a public document. So that's why at some point we'll get that deliverable date, and let the word out that shortly after that that this great work will be available.
Right. I think with turnarounds and review, et cetera, I think by the end of the year, I mean, a complete final product is you know, a decent goal.
Great. Thank you all very much. We look forward to you know, working with Audubon in the future.
Great.
and not let this product, you know, sit around. This is the beginning rather than the end.
Right, that's great.
Yeah, very good. Thanks.
Thanks again.
Anna, you probably know more about Southborough than people that grew up here.
I know a lot about it, but I don't really know my way around. I was driving this evening and I was, oh, that's Ledge Hill Road.
All in favor?
I don't even know what it looks like. I know what the plan of it looks like, but not the road is. And I know a little bit about, I mean, it's an astounding amount of development for a short amount of time. So to see that happen was pretty astounding.
Mrs. Luttrell, is the open space adjourned?
Yes, we voted.
So this is so the joint meeting is now a single session. Thank you. Thank you very much.
Hannah, thank you very much. That was wonderful.
There are, so the two members of the planning board who came tonight apparently were in the minority. The agenda item that we had, that we thought we had, didn't show up, so apparently the majority of the planning board knew about that, actually didn't, but, so no harm done in not having our quorum tonight for this meeting. And I believe it's the first time, I can't remember a time when the planning board called a meeting and failed to have an agenda, a quorum, since at least 1997. I could be wrong, but normally when the planning board calls a meeting, we do have a quorum. So fortunately tonight, no harm done. So there's no meeting to adjourn since we didn't go into session. And we'll see you at our next planning board meeting. Thanks a lot.